5 seconds to go. Start. There is a distinction between readiness and willingness to perform the contract, and both ingredients are necessary for the relief of specific performance. This court said that there was a difference between readiness and willingness to perform a contract. While readiness means the capacity of the plaintiff to perform the contract, which would include his financial position, willingness relates to the conduct of the plaintiff. The same view was taken by this court. Even in a first appeal, the first appellate court is duty bound to examine whether there was continuous readiness and willingness on the part of the plaintiff to perform the contract. It is a settled position of law that an appeal is a continuation of the proceedings of the original court. Ordinarily, the appellate jurisdiction involves a rehearing on law as well as on fact and is invoked by an aggrieved person. The first appeal is a valuable right of the appellant, and therein all questions of fact and law decided by the trial court are open for reconsideration. Therefore, the first appellate court is required to address itself to all the issues and decide the case by giving reasons. The court of first appeal must record its findings only after dealing with all issues of law as well as fact and with the evidence, oral as well as documentary, led by the parties. The judgment of the first appellate court must display conscious application of mind and record findings supported by reasons on all issues and contentions. A first appeal under Section 96 CPC is entirely different from a second appeal under Section 100. Section 100 expressly bars second appeal unless a question of law is involved in a case and the question of law so involved is substantial in nature. It is clear from the above provisions and the decisions of this court that the judgment of the first appellate court has to set out points for determination, record the decision thereon, and give its own reasons. Even when the first appellate court affirms the judgment of the trial court, it is required to comply with the requirement of Order 41, Rule 31, and non-observance of this requirement leads to infirmity in the judgment of the first appellate court. No doubt, when the appellate court agrees with the views of the trial court on evidence, it need not restate effect of evidence or reiterate reasons given by the trial court. Expression of a general agreement with the reasons given by the trial court would ordinarily suffice. Justice Arijit Pasayat, speaking for this court, reversed the judgment of the High Court, holding that High Court did not provide reasoning for its conclusion that plaintiff was ready and willing to perform his part of contract. In this case, we cannot overlook the fact that the suit property is located in the industrial town located about 30 to 40 kilometers from Bengaluru. This court is obliged to take judicial notice of the phenomenal rise in the price of real estate. To quote this court, we cannot be oblivious to reality, and the reality is constant and continuous rise in the values of urban properties fueled by large scale migration of people from rural areas to urban centers and by inflation. Stop.